can't get this council to do what has to be done. It's in the best interest of this city. So I'm going to go up to Albany, and I'm going to tell them what's in the best interest of the city is this legislation, pass it. And as long as there's a state interest in it, I would think that they can do that. He can go around this council, can't he?
Let's talk about whether there is a substantial state interest.
No, can he go around the council like that?
I
Assuming there's a state interest?
I don't, he could if there were a substantial state interest, but there is not a substantial state interest in private for-hire vehicles in
But
New
they
York
say
City.
there is, but the legislature says there is. What does that mean to us? Do we look behind what they said? They
I
say
think
quite
PBA
clearly, for two specific reasons, the mass transit and the disability. They say this is a state interest.
And let me
What do
say-
we do with that? How do we view what they say?
Your Honors have to look at the precise circumstances. The mayor, after a very short period where the council was considering compromises but wanted to make some changes, decides, my way or the highway, I'm going to go to the state legislature.
But
you are allowed, Your Honors, and this is what PBA 1 counsels. This court, quote, eschews reliance on pretextual justifications. The mayor wanted medallions to close a budget gap, and he ran to Albany to get it.
If there is a I mean, Judge Piggott's point that you acquiesce, if you find a substantial state interest, the fact that the mayor might have his own motives for asking the state to act wouldn't do it. Suppose this legislation applied to the airports. Surely there's a substantial state interest in having taxis at the airports?
Your Honors, I believe the airports would be a distinguishable circumstance.
I understand they'd be distinguishable.
It involves
but not-
regional
but-
and people traveling from outside.
But
the
still, it's the
taxis-
same private industry that you're talking about, isn't it?
Well, actually, Your Honors, those are actually public lands, publicly owned lands. The city actually has the leases for the airports. But, Your Honor, the record, undisputed in this record, was that you can't make a pickup for a taxi cab in New York City other than within the 5 boroughs of New York City, and less than 2% of drop-offs. This is what Justice Engoron found.
2% is a pretty big number, though, of all
Very
those
small,
rides.
very small number, Your Honor. Less than 2% of drop-offs ever
2%
occur
of
outside the city.
what's
Well, maybe
the
that's because you don't
denominator?
go there.
2159. That's
Isn't that
not
'cause you don't go there?
That's not true, Your Honor. And the fact of the matter is, this is a local, private industry. 75 years of tradition recognized. And let's look at the circumstances of the legislation, Your Honors, which you have a right to do. You eschew pretextual justifications after the fact by the state and the city to try and prop this law up. What really happened? Bloomberg goes to Albany and says, I want this done. Bill is introduced on June 18th, 2011. 3 days later, no hearings, no discussion. You never heard a word in Albany about any concerns about taxi pickups in New York City or the disabled in New York City being able to get a taxi. 3 days later, the Assembly pushes that out in record time. 3 days later, the state Senate pushes out in record time. No hearings, no discussion ever in the history of the state legislature did they ever have a hearing on the New York City taxi industry. Meanwhile, in New York City, we had been regulating. We
So
had
are you
made
saying-
medallions require
Counsel,
disability access,
Counsel,
and
are
we
you
had
s-
new laws to require
Counsel, but are you saying
that they pick up people in all boroughs.
Are you saying that they acted so quickly, that means that there was no legitimate state interest? What I mean
I am
is,
saying-
are you saying that the speed in which it happened and the way it happened undercuts their stated state interest? Is that your argument?
Absolutely correct, Your Honors. You can eschew pretextual justifications. Look at the surrounding circumstances and know what happened here. This isn't state legislation that was passed in furtherance of substantial state interest or in all those particulars. I mean, they required every detail and turned it all over to the mayor to do, cutting out the city council completely. This wasn't the state legislature making any record. There was no legislative history. There was no hearing, no debate. It never came up. This was Bloomberg's bill that the state legislature rubber-stamped in record time, and then they came up with pretextual justifications afterwards. If they get away with this, this is such an affront to home rule and what New York City deserves, and it deserves to be defended here in its rights, and it's an affront to what the state should do to a city when 75 years of history tell you that the state has no role in the local taxi industry in New York City, just as it should have no role in the local taxi industry in Buffalo. And if they cared about disabilities and pickups, why wasn't this made a rule of general application so that you have to have disability pickups in
Counsel,
Buffalo and you have to have them in the
Counsel,
Bronx?
one last question. No role or no interest? Which one? Or is they synonymous?
Your Honor, I think it is clear and under your precedents, PBA 1 and Osborne, you have a right to look at the surrounding circumstances and the history and tradition and the way this bill got passed, and it stinks, and determine that it's pretextual justifications now for something that was done solely at the mayor's behest to raise money, not for all these nice things that they're saying after the fact. But even if you did consider there to be some kind of substantial state interest, even though the state has never expressed the position that it had any substantial state interest in the local private for-hire taxi industry in New York City, where you can't make a pickup anywhere but New York City, and all drop-offs other than less than 2% are in New York City. Even if you looked at that, how on earth, and my colleagues will tell this, can the minute detail of this statute and the power shifting that went on in New York City to cut out the city council and give Bloomberg all the power, how on earth can you say that that is reasonably and directly related to what they say are the substantial state interests? It isn't. And finally, Your Honors,
Go ahead, Counsel.
the evidence that this is Bloomberg's bill not being pushed by the state legislature or the governor is that they put a poison pill in the bill. They told you, we're doing this for Bloomberg. And if any piece, any one piece, is no good because it's not reasonably and directly related to the substantial state interest, and in many respects these aren't, the bill dies. Bloomberg's bill dies. Don't let this mayor get away with this affront to our local democracy. Don't let the state.
What should we do if we are convinced, hypothetically, that there's no substantial state interest in anything except the handicap access? How does the case come out? If we think there is a substantial state interest in the handicap access?
It goes down anyway, Your Honor, because every little element of this bill isn't reasonably related to a disability access claim. And again, I can only repeat to Your Honor.
No, it's okay. You answered the
If that
question.
were the case, where were the hearings? Where's the legislative
Thank you.
record? And why isn't Buffalo included? And why isn't Syracuse included?
Thank you, Counsel.
Thank you very much, Judge. Thank you for all the time. Very important case as always.
Thank you, Counsel. Counselor,
Thank you, Your Honors.
proceed.
The one thing that there can be no debate about is that there is no legislative history, no findings, and no policy that underpins the notion that the power to issue medallions should be transferred to the mayor, up to 2,000 medallions generating $2 billion.
What's the significance of it being transferred to the mayor? Is it just an implementation thing?
Well,
That-
you heard-
That it's going to be done anyway. They've set the policy. What's
No,
the
it's by
difference?
no means an implementation thing. First of all,
It's a
there's
public auction, though, isn't it?
well, it's a discretion. It's not 2,000, it's up to 2,000. How you put that in the marketplace is a major factor. You heard counsel for the AG say that this was an important factor. He didn't just say it was implementation. He said it was important.
What's wrong with your adversary's argument? That he says, look, if you grant that there's a substantial state interest, which I know you don't, but assume there's a substantial
it,
state
right.
interest, assume that assume the legislature actually wants to effectuate this program, why is it such a bad idea to give it to the guy who's actually in favor of the program instead of against it?
Because that's the essence of what violates home rule. There's no justification for it in the state legislation. It is essentially a special law because it only affects the powers of New York City government.
Okay, but it is, I don't know whether you call it implementation
Hey,
or
there
not.
may be
It's obvious that moving the power from the council to the mayor was a means to an end,
Well,
isn't it?
but that's what home rule protects. That's tautological, what
Counselor,
you're
if they
saying.
had given it to the city council, would that have been okay?
If it were the city council, it would have been.
If the legislation, the state legislation gave the power to the city council, would it have been okay?
That's where it has resided forever. That's where the charter carefully and thoughtfully allocated it in 1989 and
Would
1990.
you still be here complaining there were 2,000 new licenses?
I would not be here. I would not be here complaining on the ground that I'm arguing. No, because the city council has the power and the discretion. With the issues that Mr. Mastro has addressed would still be before you.
If the state legislation said
Yes.
there's going to be 2,000 new medallions
Oh.
at public auction, but they gave the ability to the city council to run the auctions, would you still be here?
Well, that's the essence of the point, Judge Grafeo, because I wouldn't. Because the fact is, if it's non-discretionary, if it didn't matter, if there was, assuming there's state interest, which I do for purposes of answering your question, then the discretion is key. The fact is that the city council has always had discretion. And there's no reason that the city council couldn't do exactly what the mayor has been given to do, because they've always done it.
Assume
So
you've got a
yes, you're
case
right.
where
It wouldn't be here.
Assume you've got a case where even you would concede there's a substantial state interest. Let's say there's an epidemic, a major health problem in the city. You agree if there's pestilence in the city, there's a substantial state interest in controlling it.
Yes.
And suppose the legislature decides that it thinks the mayor will do a better job than the city council of implementing certain measures necessary to control pestilence. Can the legislature say only the mayor does this, the council stays
With
out?
the proper findings. And if there's some reasonable basis that the legislature makes findings to say the city council is hamstrung by its own
Well, do you need to find the reason here is self-evident. The reason is the council's against the program.
But the council, if it's ordered to issue up to $2 billion and there's a budget gap, and by the way, the power of the purse, which is in the council also, is the essence of Adler and in the essence of your cases that say where home rule counts the most. If the council has always done it and always handled the dispensation to raise the money for the budget, which of course was driving this whole thing, then the council is you have to, in order to take that away from the council under home rule, otherwise you eviscerate home rule, you have to come up with legislative findings which are rational and make sense. PBA 1 says that.
Counsel, where does
Yes.
it say you have to come up with legislative findings? Why can't you say, what's wrong with the way they did it? Putting aside the speed, they say, this is our findings, in effect, that this is state interest for this reason, that reason, the other reason. Why do they have to hold a hearing and make a finding? Why isn't that good enough?
They have to have a basis. And PBA 1, which is the
Do we
clear...
look behind it and say, on what basis? Do we say it
I don't-
doesn't make sense?
You have to
What do
give
we say?
enormous deference to any findings. No findings were made with respect to why the mayor,
But they're
as opposed to
telling
this...
you what their findings are.
No, they aren't telling us what the findings are. In fact, PBA 1 says the findings have to be made at the time the legislation is passed, and you cannot do post hoc rationalization about the findings.
So that they
It
didn't
says it
give a
very clearly.
rationale?
Excuse
that
me?
They didn't give a rationale as to why they're giving it to the mayor?
No
Is
rationale.
that enough to sink this bill?
Absolutely, under home rule
On that
precedent.
one piece.
On that one piece, and the reason, here's how important it is. The poison pill that the legislature put in Section 3, Article 3, says one part of this thing goes, everything goes. However, if you have licenses that are issued previous to the time it's declared unconstitutional, they remain in effect. So the poison pill was an artfully drawn statute. It was an artfully drawn section of the statute. And they didn't say anywhere, they obviously thought it was very important that the mayor get this power, the AG said as much. They didn't say that if the mayor, they didn't carve out if the mayor's power is ruled unconstitutional by this court, they didn't say that that will not be counted. So they put pressure on you. Their whole thing was to put pressure on this court to have what this court, they hoped, would see as the good policy of outer boroughs and of disabled, and then eviscerate home rule by leveraging the home rule violation into something of good policy by using the poison pill. And that was very cynical. And it clearly is something that is putting pressure on you, which I say you shouldn't bow to.
It's not the first time the state legislature's used a poison pill, though. It's a
I'm
fairly
sure-
common
I know, but in this case, it was used in a way to eviscerate fundamental home rule principles, because shifting of power within the institutions of the city, of the municipalities, is the essence of what home rule protects. It's much more than property.
That can't be done. It's impossible to do that? Is that what you're saying?
No, you can do it, but you have to have a general law. They do it with general laws all the time. The municipal law changes powers throughout the state among officials and affects separation of powers all the time. You can't focus in on one
So
place.
it had to be Buffalo, Syracuse, Albany, every place.
Yeah, you can't, that's right. You can't do it. That's the whole point of the history of home rule. Starting in 1894, 1924, 1938, 1963, is a whole history of the people approving through the Constitution the sacrosanct nature of local governmental separation of powers, allocation of powers, local governmental offices. Just think of the mischief that could be done in a bill like this one. You could take away the controller's power to approve any of the contracts.
What if they reallocated the power, but they made findings, at least that they put in the bill that said, we're giving it to the mayor because it's easier for him to give these out, or less costly, or whatever.
I wouldn't be here.
That would be.
I wouldn't be here.
Why can't they do that tomorrow?
Well, it's a technical area. They can do it tomorrow, but in the meantime, this poison pill throws out the whole thing, and they'll never pass it again. It'll never happen again. They're here desperate to hold on to this thing, knowing that they violated home rule. They know that they've undercut themselves by doing this, and they're trying to put the pressure on you to approve it by saying, oh, it's good policy, it's wonderful. They don't even dispute our separation of powers thing. They try and diminish it as an implementation matter, as a minor implementation matter. Well, they say themselves that it's important that the mayor has it, on the one hand. On the other hand, they say it's minor implementation. Moreover, it's clear that it's serious power. It's in the charter. It's careful. It's been in the charter for 70 or 80 years. It is a matter of very subtle discretion as to how you issue these medallions and how you put them in the marketplace. They can be devalued, they can be undermined terribly. If the mayor does it, as the city council has the history and the custom and the practice and the power of doing it, and the poison pill itself, as I said, shows. Now, they also
Right, but
make...
so the state decides that they have a substantial state interest.
Yes.
They think the city's not doing it right. And they step in.
But they can't undermine the separation of powers of the city, because that is sacrosanct. That is the constitutional duty of this court to
But
protect.
wait a minute, I thought you said they could, as long as they had hearings, that they could transfer it from the city council.
If they made findings of supervening state interest that the city council was sabotaging the effort of some substantial...
Has to be that extreme?
The pestilence, the pestilence hypothetical.
That they would undermine the law? You mean they actually have to fine?
Yes, under PBA 1, they have to make findings. If you read PBA 1, and Judge Bundy Smith distinguished it on these grounds very carefully in PBA 2, and if you look at the way the Taylor law was handled in PBA 1 and PBA 2 with the option for PERBs and mini-PERBs, it's very much the same as this. There's an overall substantial state interest in the Taylor law, but in PBA 1, they ruled that there was no substantial state interest in prohibiting New York City from having a mini-PERB, which is what the legislature did. It was very much the same, and if you look at the way that Judge Bundy Smith distinguished it, you can be very clear as to how one major shifting of power within a statute isn't just an implementation thing, isn't just a minor thing, it's part of a whole statutory scheme, and the opening of the door to mischief under home rule will do terrible things to Buffalo and Rochester and everywhere else. Home rule is a very, very narrow doctrine. It's very, very technical. This court has dealt with it many, many times and narrowed it often, but it still exists and it means something, and the people of New York have approved it over and over again in language that is attempted to expand it, notwithstanding judicial interpretations of it narrowing.
Thank you.
Thank you very much.
Appreciate it. Counsel? Go ahead, Counsel.
May it please the court, Stephen Mintz on behalf of the Greater New York Taxi Association. We are the largest provider of hybrid fleets and accessible cabs in New York, and frankly, out of the 220 accessible cabs, we account for 180 of them, and we are 100% of all the corporate accessible cabs. So the issue of accessibility from where I stand is the tail that wags the dog that was thrown in to help try to justify...
But you agree that that could be a legitimate state interest?
I think that could be done, as my colleague said, as a general law, and that's how it should have been done.
The governor saw it. I mean, he held up enactment of the statute.
He
in order
did.
to- In order to conduct
we're gonna-
further discussions.
Sure, as we've all been talking about, then we're back to substantial state interest. If it was really a state concern, you do a general law, and then the cities apply it, and I don't think that would have been a problem. The sale of 2,000 medallions of accessible cabs by itself wouldn't have been a
Well, wait a minute.
problem.
If it's a substantial state concern, you don't have to act by general law. You can act by special law. That's what Adler says.
If it's a substantial state concern and
Are
then
you
it's rationally
disputing,
done.
are you disputing that handicapped access is a substantial state concern?
I think when you point it only to New York City, then you have a problem. It's either an interest that has to be solved, and it can be.
So you're saying that there's no substantial interest outside New York City's borders in seeing that handicapped people in the city have enough taxi cabs?
Either there is or there isn't a need in the state of New York.
Why isn't the issue of handicapped tourists who go to New York City a state concern?
Well, now we start down the path. So I think what I'd like to do, and I think it's important for some of our colleagues up here from upstate, is to get a sense of some real New York City taxi stuff.
Yeah, but
that-
what's the answer to Judge Graffio's question?
As to whether or not there's an interest in tourists having accessible cabs, I think it would be a good thing if there were more accessible cabs.
Yeah, but why
I think
isn't
the
it-
city
why isn't-
council agrees
But why
that it would be a
isn't
good
that
thing if there were more
why-
accessible
But her
cabs.
question is, why isn't it a legitimate state interest
Well-
as to whether tourists are able to come to New York City and have accessible cabs?
I
I mean,
don't.
tourism has a major effect on the state's
Sure.
economy.
And once you step on the tourism in New York City, home rule's gone for New York City, because everything ultimately has to do with tourism. And now we're talking about the theaters, and now we're talking about pedicabs, and we're talking about hot dog vendors, and we're talking about hospitals that have to deal with tourists. Now we're down the slippery slope. So if we go back and we start
But
with
what-
Wombat,
Yeah,
and
but what about, but that doesn't really answer the question. What about all those things you just talked about? Why aren't they legitimate state interests?
well, then there is no local interest in anything, and that's why the delegation argument
Wait a minute.
proves too much.
Home rule has two aspects. The city is, no one's saying the city is not free to legislate in this area. The home rule gives power to the city, and it excludes the state. As I read our cases, the area from which the state is excluded is very, very narrow. It's only those areas in which the state has no substantial interest. Am I reading that correctly?
Well, I don't read it the same way you do, Judge Smith. I read PBA 1 as setting forth some more limitations on the state's power. I think PBA 1 by Justice Levine actually is a good, modern statement of the Cardozo concurrence. And I think he makes clear that you're going to reject presumptions of constitutionality. You're not going to apply minimum scrutiny. You're going to question whether or not there truly is a substantial state interest and it has to be directly related. And you're going to do it only if there's a supervening state concern that relates to life, health, and the quality of life. And that we know when you look at Osborne, whether firefighters were well rested and could save people in fires wasn't enough because of the history of municipalities controlling firefighters. The question was raised about, does that history matter? Well, in Wombat, all but conclusive of the aspect of the issue is the constitutional and legislative history stretching over 80 years. That was to preserve the Adirondacks.
So the state
Here-
says that there is an interest in access to transportation, that has been a long-time interest. Sounds
Mass-
persuasive to me. Why
Mass
not?
transportation. Mass transportation.
And you're trying to
I-
suggest
I'm not
city cabs are
accepting-
not part of mass
I'm not
transportation?
accepting that private taxi industry, to pick somebody up and bring them to another location is mass transportation. That's their argument. That is not
Why is it
our
not
argument.
mass transportation? Because it's a couple of people in the
Mass
cab?
transportation is to move groups of people around, not private individuals seeking a for-hire vehicle to take them somewhere. One of the things that you need to get a flavor of here is in Staten Island and Richmond Terrace, there aren't cabs cruising, and there haven't been for a long time. Why? Supply and demand. People live in private homes, they have cars. If somebody wants to get a taxi to take them to the airport, they call. Cabs don't cruise Mill Basin in Brooklyn or Bayside, Queens for the same reasons. They call the cab service. If they need it, they go. The yellow
I hate to
cabs,
sound like I'm a sports nut or something, but if I want to go watch the Brooklyn Nets play,
yeah,
and I'm from
take the subway.
and I'm from Buffalo, I can't even find the subway.
Take,
Can I get it? Can I get a yellow cab to take me there?
yeah, so what will happen is you'll get a yellow cab, it'll take you. And then the real problem that
Getting home.
has to be talked about is the big elephant in the room, which is to add 18,000 cars to cruise the outer boroughs looking for street hails that don't really exist. There aren't enough people going down their driveway. to
Maybe that's
ask
because
the-
there are no cabs out.
No, I think that's a chicken and egg, and actually, I think the reason why there aren't is because there aren't enough chickens standing at the end of their driveway trying to hail a cab in a private residential neighborhood.
Where's the record
So
on that?
now, we have 18,000 additional vehicles who might get a fare, who come into New York City, and we know what's gonna happen. They're now gonna pick up an illegal
Couldn't the
fare.
legislature reasonably say, we're not going to decide, we'll let the forces of supply and demand decide what's too many cabs and too many passengers?
But they didn't do that, and that's exactly what the city council has been doing for 75 years, carefully dealing with supply and demand since the Haas Act in 1937, because
And
there
is
was
it
Wild
possible the
West
state
of
says we're
cabs.
not satisfied the way you've dealt with it, and we have a state interest?
And that's
in it?
why double enactment can't be ignored. That was your question, Judge Piggott. Double enactment. If they
Okay,
actually did
Counselor-
double enactment,
Counselor-
this wouldn't
Counselor,
pass. Thank you.
Okay, thank you, appreciate it. Counselor Rebuttal.
Thank you, Your Honor. First, Judge Smith, the only other case that comes to mind is Elm Street, but it was under other circumstances that the state lost that home rule case.
Counsel,
Yes.
focus on this issue of private. This seems to be so much of the case of your adversaries. Why isn't this a private enterprise, picks up private people? Why isn't that something that the state really doesn't have substantial state in, particularly within the confines of New York City rather than throughout the state?
I would go back to the Rudak case, Your Honor, that this court affirmed without opinion. Special term in Rudak made clear that the taxicab industry forms a vital part of New York City's transportation system. After all, we're talking about 55...
But it's a private vital part of it.
Yes, it is, but it's a private adjunct to the rest of the New York City transportation system. And in New York City, where the...
So why isn't that governed by the city as opposed to these kind of more typically mass transit, what we would describe as mass
The
transit?
city has been regulating it, and now the state has decided that the state needs to step in because the state isn't satisfied.
I'll give you an example. I mean, let's assume for a minute that the yellow cabs want more medallions, and the city council agrees with it and passes it, and the mayor keeps vetoing it. Can they go to Albany and get a special bill that says that there'll be more yellow cab medallions in the city of New York?
The legislature can, if the legislature has the power to do it, and the legislature does have the power to do it.
Your answer is yes.
Then the political, that's right, the political motivations or the speculation about the political motivation is irrelevant.
But they'd have to show that there's a state interest. I
They'd
mean,
have, of course, those criteria would have to be satisfied.
Suppose hypothetically, the question I put to your adversary, suppose hypothetically that we decide the only substantial state interest here is the handicapped access, but it's there. Does that suffice all by itself to save the bill?
Either one of the two aspects of this bill is enough to save it.
So I can do anything I want as long as I throw handicap access into the bill and make it non-severable if I'm the state?
It has to be a legitimate substantial state interest, and for all the reasons we've shown, that interest in accessibility of the
Yeah, okay,
transportation.
but once I've got one substantial state interest, I can combine it with anything else in the world. I can change, I can regulate parks and whatever I
Your
want.
Honor, of course, there's a rational basis test for any legislation, and if there are arbitrary provisions, they can be struck or stricken. But that doesn't mean that this court should go through this Hale Act or any special law, provision by provision, asking whether each provision satisfies some independent substantial state interest test. That's not what this court has
Counselor,
done.
what about, your adversary makes the argument that there's really no findings here, that there's some conclusory statements about what substantial state interest is, but nobody made any findings about what this is all about.
Those findings aren't necessary, Your Honor, and certainly not with respect to each provision and each means the legislature chooses. That's
But even
hotel-
in
that's-
general, you'd acknowledge this happened very quickly. There's again, a general statement about the state interest, and that's it. Does that lead to a kind of looking behind what it says, as opposed to if it had gone through a more comprehensive process with hearings, findings, and a lot of detail on it? Contrast the two situations in terms of the judicial review of what goes on here. How do we not look behind it when it would appear it's kind of shallow to some degree? It's just a statement.
Let me try to address that.
Yes, please.
In Hotel Dorset, this court made clear that when the legislature acts, it is presumed that there are facts to support what the legislature has done, and this court presumes that the state of affairs of
So
legislature.
basically,
And
we,
there's-
we have to honor that, we defer to the legislative branch of government
It's-
and its stated, state interest, whatever it is.
But there's a lot of deference due, but this court can go further and look at the kinds of evidence that I was mentioning earlier. By the way, there's nothing in this record that overcomes that presumption. But this court can also look at its own precedent, which supports the substantial state interest articulated here, previous legislative declarations dating back to 1936, all of which are consistent with the substantial state interest, and previous state laws.
Okay,
But it's really, if I can make one more point.
One more point, go ahead.
I have so many, but I'd like